Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thanks for watching. Happy 4th of July weekend. First on the docket, Lori Vallow. Charges dismissed? What? Second, Ghislaine Maxwell. The suicide watch begins. Day 2. Third, Vanessa Guillen update. Fourth, 2 lawyers accused of throwing Molotov cocktails at New York Police Department vehicles get to go home, at least for now, and our dumb criminal contestant of the day and our winner for the week. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thanks for watching. As we roll into the 4th of July weekend, we hope you have a great 4th of July. If you haven't already done so, we would ask that you would please hit that subscribe button, hit that like button, and hit that little bell so that you receive notifications of when we go live or put up new content. First on the docket, Lori Vallow. You thought we'd make it at least one day without talking about Lori Vallow? Guess not. Well, guess what the news is today. According to the East Idaho News, the 2 felony counts of desertion and non-support of children have been dismissed. This is just days after Vallow has been charged with 2 felony counts of conspiracy to commit destruction, alteration, or concealment of evidence. My first thought is, what? Okay, so I went back and I pulled the charging documents. I went and looked at the jury instructions for Idaho, and I do not see any reason why the district attorney would want to dismiss these charges. They can still prove that during these dates that Ms. Vallow deserted these children. Even whatever their defense may be, oh, we didn't desert them. Poor Mr. Alex Cox, my brother is the one that possibly killed them. Don't see how that's still not a desertion charge. In my humble opinion, I think that the prosecutor could prove that case. The other thing is the charge for the desertion carries up to 14 years per count as a maximum penalty. The counts relating to the conspiracy to commit destruction, alteration, and concealment of evidence only carry 5 years per count. I'm not exactly sure what the district attorney is thinking. Maybe there's something else coming down the road, maybe potentially murder charges. Who knows at this point? But I'm not really sure I understand those charging decisions. I've reviewed the public information about the court file that I can, and I do not see any filing of charges. It'll probably show up Monday morning if that is in fact the case. But I still just don't understand what they're doing. Next on the docket, Ghislaine Maxwell. That's right. Ghislaine Maxwell was the friend, confidant, and one-time girlfriend of a guy that maybe was suicided while in custody, but we'll simply refer to him as the West Palm Beach pimp simply because, well, if we say his name, YouTube will demonetize us. So we're going to give this a shot. But you all know who we're talking about, right? Hint, hint, wink, wink, nudge, nudge, say no more, say no more. We know who we're talking about. Anyway, Ghislaine Maxwell, who took care of all of his travel arrangements, took care of all his meetings. His right-hand woman is in custody. She is being charged in federal court in the Southern District of New York as it relates to the ongoing solicitation of children case, the case that was pending basically against the former West Palm Beach pimp, but he was suicided, and so charges were dismissed. Now, this is going to get good. A detention hearing will take place, and the prosecutors have filed a pre-trial petition as to why Ms. Maxwell should remain in custody. The prosecutors think that she needs to remain in custody because she is facing up to 35 years behind bars, and obviously she is in her late 50s, so a maximum sentence would certainly be a life sentence. Prosecutors also allege that she has extensive international ties that would make it exceptionally easy for her to flee the country and live abroad. Now, Maxwell is a naturalized citizen. She obtained that status back in 2002, but she is still also a citizen of France. Also has citizenship in the United Kingdom. And according to prosecutors, she has passports for all three countries. Prosecutors have also been able to determine and are concerned by the fact that she has access to some 15 bank accounts that were held by or associated with the former West Palm Beach pimp, and at most times they have at least $20 million in those accounts. The prosecutors believe that those resources could be used for her to flee the country. Prosecutors are also concerned that she has effectively been hiding away for approximately a year in New England. Most recently, she was holed up in a 158-acre spread in Bradford, New Hampshire, where she was arrested. And this property was purchased for cash in December through a series of limited liability companies to protect her privacy. And finally, the prosecutors allege that there's nothing really keeping her in the United States. She has no children, she has no job, she has no family here, and that there are no bail conditions that could reasonably assure the defendant's appearance in this case. Now, certainly the defense will argue that Ms. Maxwell has certainly been subject to a lot of litigation, as she is a defendant in a lot of the civil suits alleging misconduct by the former West Palm Beach pimp, and she has not fled. She is living in the United States, and if she wanted to travel, she could have obviously done so. The mere fact that she knew that these charges were probably coming down and she didn't flee are a great indicator that she, in fact, is not a flight risk. And additionally, the defense would argue that the bail needs to be no greater than reasonably necessary to assure her appearance as well as to protect the community. There's no indication that she has committed any other crimes alleged other than what's in the indictment, and the court can certainly tailor reasonable conditions in which to assure her appearance and the safety of the community. If that is denied and the court does not grant her bail, it's more than likely that that will be appealed to the district court and ultimately to the Second Circuit. If somebody doesn't get the order that they like from the court, expect appeals to ensue. Ms. Maxwell has been involved in lots of civil litigation. In fact, the civil litigation that's taking place involves a Denver attorney. And her attorney, by the name of Laura Menninger, is a very smart woman. I know this woman. She is a top-notch attorney, and Ms. Maxwell is in good hands. I'm assuming that she will be the attorney for Ms. Maxwell at her detention hearing next week, as she is a licensed attorney not only here in the state of Colorado, but New York. And since she is familiar with the matter as it relates to the civil case, it's very likely that she will do that. Now, we are going to start a little clock here as it relates to Miss Maxwell. As we know, the former West Palm Beach pimp was suicided. In fact, I think they actually created that word just for him because apparently he got the word one day and said, yes, you have been suicided. And he obviously passed away in his cell via his alleged suicide. Anyway, so we're starting the clock to make sure Miss Maxwell doesn't get suicided. We hope that while she's in custody and if she is released, that better security is in place than they had for the West Palm Beach pimp. So today, since she was only arrested yesterday, is day 2 of the Ghislaine Maxwell suicided watch. We'll continue the countdown daily. So before we go on, let's take a quick recess. Now, listen, as you're sitting around this weekend and you're watching these YouTube videos and you're watching everything that we talk about in the world, what is the one thing that you would love to know about a lot of these people? Well, guess what? You can do a background search on any number of people. In fact, anyone in the United States, you choose to do so, and you can do it anonymously. If you go to CrimeTalkSearch.com, you can sign up for a background search description, and literally billions of records from millions of public resources across the United States will be searched, and in a matter of minutes, you will receive a report. And in that report, it will include social media, it will include criminal records, bankruptcies, property records, just about anything you need to know about a person that you want to be involved with, whether it's a friend, a business associate, maybe a new love in your life. It only takes a few minutes. You can do it as many times as you want, as long as you have the subscription. You can cancel any time. You can do it anonymously. You will be satisfied. Go to crimetalksearch.com and sign up today. Next on the docket, Vanessa Guillen update. As we told you yesterday, so if you want to watch the video, very graphic details as it relates to Miss Guillen's disappearance and the discovery of her remains in Texas are all right there for you to watch. I'm sure we can put a link up to that. But today's breaking news is that the suspect allegedly involved in the disappearance of Fort Hood soldier Vanessa Guillen now faces federal charges. That's right. The United States Attorney for the Western District of Texas announced that Cecily Ann Aguilar has been charged with one count of conspiracy to tamper with evidence. The charges comes after authorities uncovered the human remains in Bell County on Tuesday. That's in Texas, and they believe that those are the remains of 20-year-old Guillen, who disappeared from Fort Hood on April 22nd of 2020. According to the complaint against Aguilar, it's alleged that she helped Army Specialist Aaron Robinson, who's also 20 years of age, mutilate and dispose of Guillen's body after Robinson had beaten her to death on base. The complaint further alleges that Robinson told Aguilar that he had killed a female soldier with a hammer on base on April 22nd and that he had taken the body to a remote site in Bell County, Texas. Robinson then got Aguilar to help him dispose of her body. Although the remains have not been formally identified, statements by Ms. Guillen's family and their attorney state that those are, in fact, the remains of Ms. Guillen. There hasn't been formal charges as it relates to Aaron Robinson, but since he was obviously on active duty and the crime took place on base, it would be more than likely that he would be prosecuted in a military courts-martial. And as a former judge advocate who's done many court-martials, I'll be here to give you the analysis as that case progresses. Obviously, Ms. Aguilar was a civilian, therefore the military would not have any jurisdiction over her in which to prosecute her, hence the reason why federal authorities and or state authorities would handle the case. Next on the docket, lawyers gone wild. That's right. So two New York attorneys. One is a big law firm associate in New York named Collinford Mattis, and another public interest lawyer, Uraj Rahman. Well, it is alleged that Rahman threw a Molotov cocktail during police protests in New York City on May 30th, and Mattis was the getaway driver. Rahman was also accused of trying to distribute Molotov cocktails to other people at the protest. Needless to say, these two lawyers were actually arrested and charged in federal court. The magistrate that originally heard the case decided to give the two bond. Two were released. The United States government appealed to the district court judge who would be handling the case. A magistrate judge and then a reviewing judge at the district court level concluded that Rahman and Mattis should be granted bail because of their family ties and lack of previous criminal records. The two lawyers had been held in jail pending their appeal. However, yesterday the Second Circuit granted the government's emergency motion to be heard, and then ultimately the Second Circuit concluded that the two should be released on bail. Judge Peter Hall wrote the majority opinion and was joined by Judge Gerald Lynch. Now, they state there's no question that the evidence before the district court demonstrated that the crimes charged are serious and that the defendant's conduct on the night of their arrest could well have resulted in significantly more harm than it did, Judge Hall wrote. By affirming the district's court order to release the defendants on the conditions imposed, we do not seek to minimize the severity of the offense. Rather, we recognize the constraints on our appellate review and the fact that the gravity of an offense is not the only factor to be considered by the district court in deciding whether the conditions of release are adequate to ensure the defendant will not flee and/or do not constitute a continuing threat to the community. To reverse the judge's bail decision, the court would have to conclude that the government presented clear and convincing evidence that the lawyers presented a danger to the community and that they could not be mitigated by released conditions. The court would have to be left with a definite and firm conviction that the judge's decision was wrong, and they concluded that they could not do so based upon the record. So why is this important? Obviously, you do not necessarily want Molotov-wielding lawyers out on the street, particularly if they may do it again. Somehow, I don't think they will, based upon their conditions of release. But in this particular situation, this would be the same argument that they made in the Ghislaine Maxwell, or they will make in the Ghislaine Maxwell matter, is because they face basically life in prison. These two lawyers are charged with use of an explosive device, arson, use of an explosive device to commit a felony, arson and conspiracy, use of destructive device, civil disorder, and making or possessing a destructive device. And as we noted previously in the conversation today, the mitigation factors will be the same ones made for Ghislaine Maxwell. And whichever side doesn't like the decision by the magistrate or reviewing district court judge, it would go to the Second Circuit, and it has a good possibility they would go to the same judges. So the United States attorneys that are prosecuting Ghislaine Maxwell may want to make a very thorough record because that's all that appellate courts get to review. As we've discussed before, if it's not on the record, it doesn't exist. On appeal, you don't get to bring in new facts or information that you think might be relevant. It only matters what's on the documents itself, the pages of the transcript itself. Now, Mattis is a graduate of the New York University School of Law. Rahman is a graduate of Fordham University School of Law. And apparently, some 800 people affiliated with the law school have signed an open letter calling the charges politically motivated and calling for the lawyers to be released. Now, I'm not sure what's politically motivated about charging somebody with throwing Molotov cocktails at police cars and burning them up, in particular when you're caught on video. I'm not sure what kind of free pass you get for that in this country or anywhere else in the world. I think it would be politically motivated if they were not prosecuted. We'll let you know how that one turns out, but I believe Mattis and Rahman will not be practicing law in the United States much longer. Now, for the big moment, before we get to the dumb criminal contestant of the day and the recap of the dumb criminal contestants for the week, for the big winner, let's talk about something that could help a lot of people. That's right. It's called a safety siren. Now, yesterday, we demonstrated how loud this thing is. It is 100 decibels loud. It is an ear-piercing 100 decibel alarm. And the beautiful thing about this is, ladies and gentlemen, look how small it is, all right? You take it out of the package. Look how small it is. It can fit on a keychain, all right? It has a little flashlight on it. I don't know if you can see that. It has a little flashlight on it. But more importantly, if somebody comes up to you and there's an issue, there's a disturbance, don't pull a gun, don't pull a knife. All you have to do is simply... Do you think that that would bring attention to you? Absolutely. And do you think that would bring attention to the bad guy trying to do something to you? Absolutely. And they're going to run like hell. That's right. I'm telling you, as a criminal defense attorney, I have represented lots of people. And what do they want to do? They want to go after people and things where they're not going to be noticed or they think no one's watching. Well, if you pull that pin, people will be watching and they're going to stop doing what they're doing. Go to CrimeTalkOffers.com and get a safety siren. This thing could save your life. You'll be glad you got it. Next on the docket, our dumb criminal contestant of the day. And our dumb criminal contestant of the day comes from Minnesota. And obviously, Miss Mueller is given the presumption of innocence, but Heidi Ruth Mueller, 35, sought to enter a Menards home improvement store in North Mankato, Minnesota. Heidi Ruth Mueller, 35, sought to enter a Menards home improvement store near her home in North Mankato, Minnesota. When Miss Mueller attempted to enter the business, an employee instructed her that she needed to wear a mask to keep with the store policy. Mueller began quarreling with the employee and the worker before grabbing the man's mask and pulling the mask down. After a second worker came over and intervened, she was told to leave. Miss Mueller was having none of that. Mueller slapped the first employee in the face and ripped his mask off before throwing the mask in the garbage. She then fled in the parking lot and left. Unfortunately for Miss Mueller, the matter was caught on surveillance. Now Miss Mueller has been charged with 3 misdemeanor counts of disorderly conduct and 2 counts of assault. Now, Miss Mueller, whether you agree or disagree with the mask policy, that is for a different subject. But when you enter into the business, a private business, they can restrict you from going into that business for whatever reason. And if they want you to wear a mask to get into the store, you have to wear a mask. If you don't want to put on a mask, guess what? You don't get to go into the store. It's that simple. It's a private entity. They can put any restrictions they would like on entering into their business. And Ms. Mueller, one of the things we always talk about here on Crime Talk is identification. The police have to be able to point to and say, that's the person that did it. So if you wanted to slap around a couple of people at Menards, you'd probably want to keep your mask on. Think about it. As a kid, watching those cowboy movies and the bank robbers show up, what do? They put the mask on so they couldn't be ID'd. What do people do when they go and do criminal acts? They try to hide their identity, putting a mask on. Miss Mueller, for your poor decisions, you are our dumb criminal contestant of the day and possibly our dumb criminal contestant of the week. Now for a quick recap of contestants, here we go. But one thing I have to let you know, YouTube no longer offers polls. We can't do that. So just quickly leave a quick description in the comments of who you'd vote for. We will give you the gist of who won next week. Our first contestant on Monday, the young lady who wanted the taxpayer-funded taxi ride. Remember, she's the woman that kept calling the 911 dispatch to get a free ride to the next city over. Next, on Tuesday, was our teacher who was engaging in inappropriate conduct with his students, but asked one to sign a note promising not to tell, and in exchange for that, I'll give you a B in the class. Wednesday, the guy who shot up the pizza joint because he thought that he didn't receive enough toppings on his pizza. Thursday, the church fornicating couple in Utah. And finally today, our unmasked slapper at Menards. Let us know in the comments who you think should be our dumb criminal of the day. That's all we have for you today. Thanks for watching. Have a great 4th of July. Celebrate the freedoms of America. Do it safely, and we'll see you back here next week. Have a great holiday.